Okay, doing a late night live. I didn't schedule this at all, but I was watching Lawyer, just so you guys can see, and I was getting his reaction, and I believe that our reactions are pretty close. So, we're going to listen to him, and I'm going to let you know if I agree with what he's saying, and if of course, if you watched my first live, you'll hear I had said things very similar. Okay, so there's a few things he doesn't say that I do say. So I really enjoy his program. Here we go.
I believe this to be an important issue and one that is worth getting a glance, at least from a higher court, rather than being tucked away and forgotten in the maelstrom that is to come. As the state undoubtedly knows, trial won't put an end to this case. This case will go on for 28 years if they do actually achieve a conviction. So
we don't want this to just be put away and forgotten. One thing he said. Number two, the trial is only part of this case. So it's interesting, and I agree, it's the biggest and potentially most important part of the case. But he says if they get a conviction, this case is going to go on for 28 years. And he means all the appeals, mandatory and otherwise, death penalty issues, sentencing issues, things that happen in the first phase of the case, second phase of the case. This issue is going to be an appellate issue. And we've got so much going on here that this case is going to last forever, whether we like it or not. Which I thought that was very interesting. Miraculous Hufflepuff said, why would the trial only be part of the case? The trial is only part of every case, obviously. The pre-trial phase, the discovery phase, which we're in right now with this case, is obviously part of it, and the trial is only part of it, but it's the culmination. And it's so difficult to go and win an appeal after you have been convicted. Alicia said they're talking too fast. You can slow it down to 0.75 speed, 0.5 speed. If you hit the little gearbox on my video, it'll slow it down, and it should sound perfectly normal. We're going to get through as much of this as we can. I've got a couple clips I want to show.
The idea that somehow we're running towards something and that's going to do anybody any good from their standpoint is, I think, false. What we're trying to do is make sure that the things that occur in this case are done correctly. And if you want to talk about how long things are going to take, get some stuff wrong, and then see how long it all takes. We're asking
a little threat there. You want to know how long this is going to take? Get some stuff wrong, and then see how long it's going to take. Meaning, we're going to appeal you to death. We're going to file motions for reconsideration to death. We're going to make sure everything takes long. I mean, listen, nobody wants to do it twice. We talk about that from the jump. Nobody wants appeals. Nobody wants convictions overturned. Nobody wants to do this stuff twice. But that doesn't mean you just pause the case every time the defense wants to appeal something and you let the case take forever because it's going to take forever anyways. Everybody wants to do it right. It's incredibly important, not just for the defense, but for the prosecution. We talked about that with the rights of the media and the rights of everybody else.
That the court would...
The fact I have to talk through it no matter how, you think of it. He's speeding up the sound because everybody's using this content. And eventually YouTube is going to stop certain channels from being able to continue using it. So this is another reason why YouTubers are in such a rush to get this out before anyone else, is because YouTube's only going to allow X amount of creators to use it, and then the other X amount they're not going to be allowed to. But if they are allowed to, if they try to monetize it, it will be where you have to share the monetization. It won't be fully monetized for you. So now you'll understand what the rush is all about. Now, the fact that he didn't get this out before anybody, he obviously has to speed the sound. Okay, so the sound is very important. So if you're late coming in and you don't know how many's already got the same content already put out, that's kind of what you do. You want to speed up the sound. All right.
Give us permission to go and see if the Idaho Supreme Court would be willing to weigh in on this particular subject. Whether or not the case makes its way to trial at some point is, in our mind, just part of what the court has to look at, particularly in the case where the state's decided that it wants to try to kill someone. Thank you. Particularly in the case where the state's decided that it wants to try to kill someone. Thank you.
Excuse me. Well, first of all,
Now, one thing I noticed is that he didn't stop or comment about what he said about the state wanting to kill somebody. Because this guy came out pretty blunt. And so he wasn't quite concerned with those words, or he wasn't paying attention to what was happening, because he's obviously thinking about something else, and he kind of looks angry in a way. Like, he looks like, oh my god, like I have to freaking be here, or, you know. So, I mean, I'm just looking at the demeanor of his face. Like, he's, oh, I gotta explain this to people, or I gotta continue doing this in order to make money off of YouTube kind of frustrations. Well, I know the frustration big time. I lost $35 or $38 already. Even though I'm getting the views, I'm not gaining any more revenue. It's kind of weird. So I had almost ended at 400 even for 2 months. So it'd be like 200 last month, 200 this month. They took away $38 for this month. I don't even know why they did that. I'm still, like, my views are still going up, but I'm not getting the revenue per view. It's kind of like they're cheating me and thinking I don't see it. But I'll show you. Not right now, of course. I gotta see if I made a screenshot of the 411 cents, because now I'm at the 378 and something cents. So yeah, I noticed when they deduct from me, and I think that looking in these faces that they're noticing it too.
this is a reconsideration of the order relating to dismissing the indictment, whether or not the standard for proof on a grand jury is probable cause or beyond reasonable doubt. I don't think we've done anything wrong about that. That decision was put out quite a while.
This is basically the judge saying, I did say it was a good argument. I did say it was a novel argument, but it really wasn't that good of an argument, okay? I don't think we got that wrong. I don't think anybody's going to argue with the standard of proof in a grand jury indictment. So he ends up saying no, but he's going to give his reasoning here. Kelly, thank you for gifting a membership. And Joanne asked, why does the appeals process take up to 28 years? It doesn't. I mean, it's different in every case, right? Sometimes there's trials that take 28 years to go to trial. That's a little extreme, but it does happen. And cases can take a really long time on appeal, or they can take a couple years on appeal. It usually isn't a delay. And appeal's coming no matter what in this case if there's a conviction. They're going to appeal. Even if everything was done right in this pretrial phase, they're still going to appeal. But I think it's kind of just like him showing how horrible this is all going to be, and it's going to take forever, and the trial's just part of it, which people say in literally every case because that's part of the process, that there's going to be appeals, and that does cause extreme delays usually. But there's a little bit of hyperbole there.
Okay, so due to the fact he was talking really, really fast, so everything he said is right. Even if they do get a conviction, he's still going to have room to appeal everything. But, you know, I'm still trying to understand how and what it is that they have in order to continue this charade. So let's move on a little bit. See if he even notices and mentions anything.
A while ago, it's rooted in well-settled law, and I think it was correct. Supreme Court, I guess, could turn that around, but that is doubtful in my opinion. We went through Idaho Constitution, statutes, case law, criminal laws, and really common sense. So I feel quite confident that that was a correct decision. So that is.
I agree, Judge. I think that was a correct decision because, like, everybody agrees with you across the world and for all time.
That it is well established that the standard of proof for indictment in the grand jury is probable cause, not beyond a reasonable doubt, which is the standard for trial. So putting that aside, now we get to this permission to appeal. under Rule 12. So, excuse me, let me just get this right. So, the criteria for permission to appeal, this is in Rule 12, the Idaho appellate rules. First of all, it's very, very rare in case law for such an appeal going to the Supreme Court. It does happen, but it is rare. And the court has established this criteria. And I'll just read this part of this. The issue needs to involve a controlling question of law as to which there is substantial grounds for difference of opinion. Again, in my opinion, and based in all the law in Idaho that I've found, is that there's not a difference of opinion about what the standard for the grand jury is. So the defense is making that argument. I respect that. I don't agree with that, but
It's basically like, I'm not worried that this is one I got wrong. If I was worried that maybe I could have got this one wrong, then maybe I'll let you appeal it. This ain't one of those.
that's where this is. I don't see a difference of opinion throughout the state about what the standard is for grand jury determining an indictment. This also has a second component. This is something that Mr. Nye really focused on, is which an immediate appeal from the order may materially advance the orderly resolution of the litigation. I'm very concerned about delay, and I think that if we send this to the Supreme Court, that it's going to add delay. Mr. Logston is correct. I mean, this is a complicated case. It could take a long time, longer than any of us want, but I think that would add additional delay. As I said, I'm already concerned about that. We're over a year.
There's no doubt that this would cause additional and considerable delay. YYZ, newer to this trial, is he facing the death penalty? Yes, he is. Just Amber said, would there be a new judge if there was a change of venue? Not necessarily. They changed the venue and other judges have stayed on. Sometimes they do, but I would say probably not in this case. Dang it, I started the wrong one. Somebody said, I do not see eye to eye with Judge on this one. What do you mean? Do you guys agree with Judge here or not? And also, Rebecca said, if you guys hit that like button, new members will appear. And she's right. We've hit the like button. Azam has gifted a membership. Thank you, Azam. And Rebecca has gifted 10 new memberships.
Sorry. All right, so sorry about that. I don't have it like he has it, so all right. So for this judge, when we get in further, I'm still trying to understand how come they are still doing this, why they're still trying this gentleman. I'm not understanding. That's the whole reason why I'm kind of going through this. So thank you for the thumbs up. Again, this is just a reaction on what he's coming up with here, just to help me understand a little bit more. Because again, I don't have his law degree. Okay, but I just when we hear what Ann Taylor is explaining to him, that with the things that she doesn't have, in order to be prepared, she's even explaining how even the defense team doesn't have it. So we're going to get to that because that's an issue. So here's when they do discuss that, I'm wondering how in the world do they still have enough to take him to trial if they're both basically, one of them's not even complaining with what she said, they both don't have everything. So I'm lost. I really am.
Idaho versus Todd, where the it's an old case, 1983, but the court also considers other factors, including the impact of the immediate appeal upon the parties, the effect of the delay of proceedings in the district court pending the appeal, the likelihood of possibility of second appeal after judgment is finally entered by the district court, and the case workload of the appellate courts. but it finishes with an appeal must be exceptional, seeking of that appeal. Because the Supreme Court doesn't broaden the appeals, which may be taken as a matter of right under Rule 11. So, in my opinion, I do not find that the criteria is satisfied for a permissive appeal. There's no controlling question of law where there is.
That doesn't mean they can't appeal it later, right? If there's a conviction after conviction, they can appeal it. But he's not going to give them permission to pause the case basically right now, cause a delay, and appeal it now. No surprise. I agree with the decision personally. If you disagree, let me know why.
Substantial grounds for difference of opinion. The law is settled as far as I'm concerned, and there's no difference that I'm aware of. I also do not see how the appeal could advance the case. To the contrary, it would stall the process when we really need to move forward. So I'm denying the permission for appeal. Obviously, denying the motion to reconsider. And with that, I think we are ready to go to any.
So then they go into schedule.
I'd be happy to. And to start.
Okay, so he basically denied their appeal, everything again. But that doesn't mean they won't take it to a Supreme Higher Court to go against him. So while he's creating when they're going to come back, when the trial's going to be, they still could go to the Supreme Court and rule against this whole thing. At least that's the understanding that I'm getting. But he doesn't mention it, I don't think.
Mr. Lodson said something that I think needs to be addressed. He makes the allegation the state is trying to kill someone here, and frankly, I find that offensive. What the state is trying to do is to enforce the law that our legislature has put in place. It says, in cases such as this...
My opinion, you didn't need to do this. Just let that one roll off your back, and just don't get in the mud if you think they're just making arguments that don't matter and are just trying to just scream hyperbole for the media to report on. But he decided to answer it anyways.
With facts like this, a jury is entitled to decide not only guilt but potential guilt. We are simply trying to fulfill our responsibilities under the law. To characterize it as the state is trying to kill someone is just simply appealing to raw emotion, and it has no place in this court. We would ask that not.
Yeah, but like to whose raw emotion? The judge's raw emotion? Like, who cares? Again, I did not think this was necessary personally.
Now, as to the trial,
Well, I feel that the old man that's speaking, not him, of course, was interested in the fact that those words could be used against them in media. So he's not concerned if the judge is going to see it a certain way, or the jury or anybody or the what do they call it? Witnesses are going to see anything a certain way. It's media, because media picks up on these words and really picks on it. So this man basically said that they're trying to kill somebody. And then this man doesn't want to hear that, because now you have media that writes this stuff out, like New York Times, and what if they put those words in, and people outside of this case read this, they take it out of context and start siding with this man because of the way he put it. That's what he was more concerned about. So I don't think that lawyer you know, understood where he was coming from when he made that comment that who cares, blah blah blah. The media could be cruel. Okay, so wanted to make sure I noted that. It's 29 of you. You know I deserve this. It's like 10 o'clock at night, and I'm doing this for you. And again, out of respect, I love lawyer I love his channel. I'm just happy there's an attorney who has a channel, plus the other one for Law of Andrew. Okay, so here we go.
I already noted that we have a variety of competing interests here. We have certainly the defendant's right to a speedy trial, but she is waived at this point. There are also interests of the state itself, and I think even more importantly, the victims and the families of the victims in this case, to a timely disposition of this case. Granted, this is a complicated case. It is a very serious case, and a lot of effort needs to rightly be put into it to make sure that the case is handled correctly. At the same time, we need to also balance the need to move forward in a constructive, productive fashion. When the state filed our motion asking for a scheduling order and trial date, which was a little bit over a month ago, we proposed the summer of this year. And at that time, and at this time right now, we believe that we could be prepared for trial summer of this year. We realize defense has factors and considerations they want Your Honor to take into account, and certainly we want to afford them that opportunity. I will.
So,
Okay, let's hear what he has to say, but I'll tell you what I gotta say.
that's basically the state's argument, and we read these motions together about how the state wants to have it summer of 2024 because hotel rooms and University of Idaho is out, and that just makes the most sense. Defense said, no way, we don't think we're going to be able to do it. And we kind of talked, and we thought, when we talked about this before, if you want to go back and watch the video, summer makes sense. I do agree with the state's arguments on the summer, but there ain't no way it's...
Well, before I lose my train of thought, because he'll get to talking and I'll forget, okay? So, the old man here has already taken in consideration that the defense team is not ready for this summer, okay? None of this, okay? I'm so sorry. So, he's telling the judge to hear them out, and that he is basically agreeing with them that even though these guys say they're perfectly ready for this summer, that their opponent is not, and they're more than willing to work with the opponent. Okay? So what he's saying, I'm sorry, lawyer, you look like you need to enjoy your vacation for real. So forgive me. That's how I feel about that.
happening summer of 2024. The DNA evidence is just happening now. Got to get more experts, more depots, 51 terabytes of evidence.
Okay, so the DNA they don't need. Remember, they're not using that genealogy DNA thing. They're not using it. They had already tossed it out, even though that Ann Taylor is insisting on the discovery and all that. It's only because she wants to know what led them to Bryan Kohberger. And she's going to state that in a moment, because she doesn't have anything that matches up enough to even put her in a situation if she wanted to prosecute Bryan Kohberger. If she was the prosecutor side of the defense team, nothing added up. And every single thing that she has does not add up. Now, why is this man more than willing to work with her timeline when they're telling the judge they're already ready? They're ready to go. So if they're ready to go, how in the world is she not ready to go? Okay, so that's what, in my last live, I said this is about clean up. They screwed up. Now they got to work in their screw up, and it's time to clean it up and clear his name. So this is going to be a long process, because they're going to either crush him or clear his name. And yeah, it's gonna drag out longer than you think. This is another reason why I said I had plenty of time to get content out. I had plenty of time to start the 3D chapters, because ain't none of this gonna end anytime soon, because this judge doesn't want it to end. Okay? He does not want it to end. He's like I said, he may be up for some type of election or some type of, what do they call it? Advancement somewhere, okay? He's already getting notoriety. He's already becoming a celebrity. So he's going to be moving up with that celebrity status. So, yeah, he's not trying to give that up. And then nobody remembers him? Shh. Yeah, oh yeah, okay, we'll throw out the indictment and la la la, and then, nobody remembers him, because then they gotta start all over again, come back after Bryan Kohberger differently, and he may not even be appointed judge next time. He's all about fame. That's the way I feel. He's all about the fame. That's what this judge is about, even though this man's not going to mention that. So,
The summer of 2025, and guess what? Summer of 2025 is what the defense asks for, and she said she's scared to even say that because she doesn't know if she's going to be ready. And I think that makes the most sense. As horrible as it sounds, as huge of a delay as it sounds to a normal everyday person for a case like this, death penalty case, 2-phase trial with this many issues, with this much discovery, summer of 2025 would not be a horrible amount of time for this case to take. I think that would be 2.5 years basically. That's not an abnormal amount of time. I think that would be a pretty fair amount of time. Now, will they continue to try to delay? I do think it's a little bit strange that they wanted to pause the case to appeal just that issue about the grand jury indictment, which they're going to lose. Number one, my opinion. Number two, now they're not even sure they'll be ready summer of 2025. Is the defense starting to want to delay and delay and delay? I would say no. I think based on some of the arguments, and we're going to hear some of the clips today, they really think they have some good evidence or holes in the evidence that are going to work in this case that are going to make a jury raise an eyebrow. The friends I'm here with have not been following the trial as much, and when I told them a little bit about it, they're like, well, wasn't he like stalking the girls for a while before? I'm like, I don't really know if there's evidence of that. Well, wasn't he following, DMing them on Instagram a bunch before? I was like, I don't really think there's any evidence of that either. We'll see. There were some comments and media reports, but I don't know if that's what the evidence is going to show. We got to wait and see what the trial says. They go, wait. So he wasn't stalking him. He didn't go to the school. He wasn't DMing him. He didn't date any of them in the past. So what's the big connection between him and the victims? And that's going to be some of the really important things that come out in this trial. They don't have to prove motive, but sometimes it's difficult to win without it. And, we'll be watching for that and see exactly how the prosecution can put this case together. They talk about how there's 400 witnesses. The defense gets up and says, no way we can do this trial. 400 witnesses, we only talk to 10% of them. 51 terabytes is 6.5 million documents, 13 filing cabinets worth. They agree with a bunch of what the state says, but they just think because of how complex and how much discovery there is, and this is a death penalty case, a 2-phase trial, the media is making it hard for them to talk to witnesses. People don't want to talk to them because of the issues in the case, and because the media is making this difficult. And, a lot of people hate Kohberger, so if you're going to do something good for the defense, people might not want to be involved because of the media and the reporting and all of that. And that's bad. And we don't want that. We want a fair trial. We want people to feel like they can testify to whatever they saw and whatever they know, because that's really the point. And Jenny said 400 witnesses. So it doesn't necessarily mean 400 witnesses at trial. It could mean 400 potential witnesses, or witnesses we need to talk about in discovery, or witnesses we need to depose as the defense in the state. Could be that. Mrs. Jim, all of a sudden the prosecution's ready to go, yet they haven't handed over all discovery. They forced PK to waive speedy trial. I agree. The state's got everything they want, right? But guess who doesn't? The defense. Which is why usually when they ask for a continuance, they should get it. Because they need to be prepared. They need to be ready. They need everything they need. Period. And that's what we said about the DNA stuff. And guess what? They were right, at least partially, about what they should get. Farrow said, when will this go to trial? I think summer of 2025 is when the court's going to set it. I don't think he made the decision today, but we're going to watch the rest of this. Rebecca, well then, the defense needs to get on it. Not fair to the victims, and that's exactly one of the arguments the state made. The victims have a right for this case to go, and they're correct. They do have a right. But if the defense continues to win motions to compel where the state's not turning over discovery that they're asking for, and then the judge agrees with them, and the state has to turn over some or all of the evidence they're asking for, I mean, you can't punish the defense for that. You really can't. And they have to have the opportunity to hire their experts and move the case. And again, nobody's going to want to hear it. But coming from somebody, again, like I just told you, I'm afraid and I'm ticked that this case I'm supposed to go to trial on in 3 weeks is going to get continued. And the case is almost 4 years old. And it's been continued 6 times, and we're doing everything we can to get it to go, and it's so annoying. I don't even think that the defense was trying to delay for a while, I think. I don't even think they're trying to delay now, but it's just the justice system gets so clogged up. So, to me, 2.5 years is not unreasonable. for a case that's this complex with this much discovery. All right, so let's jump in now to the next clip that we want to watch.
If you sleep on your side, I bet you hate your pillow, and this is why.
Oh, my heart.
But I'm going to need some time to do that. I wanted to let the court know as well, because the court's going to be considering a scheduling deadline for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over, another picture considering a scheduling deadline.
So let me just introduce this clip before we get to it. This is the major hole in the evidence that the defense is bringing up now, saying, I've read this probable cause affidavit over and over again. They have 51 terabytes of discovery that they've had for months now, most of it. And she's gone through all that. So she's telling us something without telling us. And there's no evidence of a connection. How did they get to Bryan Kohberger? How did they find him? How did they lock in on him? And that's something that they're definitely going to fight. And so let's hear her discuss exactly what they think is missing in this case.
Line for 12B motions. I want us to have a clear picture before we have that deadline. And the clear picture that I'm concerned about is the state's pathway of how Bryan Kohberger comes to their attention and is identified. I've read that PC affidavit over and over.
Okay, clear pathway, y'all. She doesn't have a clear pathway on how they connected Bryan Kohberger to the incident. So if she doesn't have it, there's no way the defense team has it. I mean, the prosecution would have it. I'm sorry, but something's not right here. So, Judge. If I was Ann Taylor, I would go to the Supreme Court. I would literally say, fuck you. I'm going to the Supreme Court with every single thing here. I'm gonna find out, buddy, if money is lining your pockets so that you're keeping this shit alive. I don't know if anybody agrees with me, but if you do, hit the like button. If you don't touch the like button. Okay? But I'm just not the one. I mean, I'll be kind here. Yeah, I'll be as, respectful as I possibly can here. But I'm going behind your motherfucking back, and I'm going to the fucking Supreme Court and say something's not right between this judge and the prosecution. Something's wrong. Okay? So if she does not have, and you can read it right down here, I'm not even going to be able to say it. I have speech impediment. Okay? She does not have anything that ties Bryan Kohberger to this case besides their DNA bullshit that they don't want to use. Oh, we're not going to use that. We're throwing it out. So what do you have? Is a witness? Do they get to cross-examine this witness? I mean, what's going on here? Because this is bullshit. I swear to God, if I was sitting fucking here, I'd be like, you know what, Ann Taylor, I'm ready for the Supreme Court. I mean, I don't know the law and all. Maybe she has to wait. Maybe she can't. I don't know, but I'll be like ready. Not only am I fighting the prosecution, I'll be fighting the motherfucking judge on this. So how many times you're gonna sit there and deny something that is in front of our face? There's nothing. And then he doesn't even stand up for the fact, Ann Taylor, you do. Ann Taylor, the reason why I'm denying this is because I seen the connection. No, you're not saying nothing like that, are you, Judge? Why are you denying it? That motion is sealed still? You bullshit. Sorry, that's how I feel. You bullshit motherfucking son of a bitch. Alright, I'm gonna stop. I'm gonna let this nice young man finish talking. He's got more education than I do. Here we go.
Over and over again, and I'm not sure. Over a year into this case, and everything I've read, and I've spoken with our team, we're not sure how the state decides on Bryan Kohberger. I know different pieces, but I don't know where they fit together.
If I'm the state, and that's true, now maybe she's just blowing smoke, who knows? But if I'm the state and that's true, and she can't figure it out, my guess is a good defense attorney is going to be able to convince a jury How are we sure? How did they get here? I can't even figure it out. How are you going to figure it out? How did they figure it out?
Okay. Hello? Knock knock, who's there? Anybody? Hit that like button, because you know fucking right. It's called cleanup time. This motherfucker's fucked up. They can't come up with this shit right. It either A, they gotta find who was with him on this, or who really did it. Okay. Ann Taylor is completely in the dark, just like the media. Alright, Judge, what else you gotta say to that? Huh, Judge? Man, I wish I was in the court. I'd be like,
That's not good for the state. No matter how you cut it, that is just not good for the state.
And the more work I do, the less I know about how they fit together. And that is critical for us to assess 12B motions. So while the court's doing deadlines for discovery, I need the court to have something with the 12B keyed on when I have full discovery. I also think it would be appropriate for the court to...
She's like, we need those answers. They've got to tell us those answers. We need a deadline as to when they have to turn over those answers. And if you look at the judge, he's making notes.
allow windows to file additional motions based on later disclosed materials too.
Sorry, let me pause it again here. I'll just tell you, from my perspective, that is unusual. Usually we know how they found our client, the criminal defendant, easily explainable, makes sense. Even if you think he didn't do it, whatever it may be, Paige Willow said his car on video. I think there's some holes there, Paige. Now, maybe the state can put it all together and figure it all out, but this is the interesting part of the case, is the connections, how we got here, how he got here, why he did it. Again, not necessarily the elements they have to prove, but usually very good arguments for reasonable doubt.
I think we'll just keep getting materials until the court sets a deadline for it to be cut off. Not anybody's fault, just the magnitude of the case. And so I think that would be something appropriate for the court to set as well.
It's kind of the state's fault. And in criminal cases, the state usually delays giving evidence or giving discovery. In civil cases, it's the defense that usually delays giving discovery. And then it makes it so problematic. I mean, I have cases where civil defense attorneys are just turning stuff over until the day of trial, and it's so unfair. How can you prep? How can you get ready? How can you know what you have to respond with if they're not giving you everything? The state needs to turn all this stuff over. They've had it for over a year. They need to turn over everything that's relevant that the defense is asking for. If not, the court needs to rule on motions to compel discovery. Now, the defense keeps saying it's not the state's fault. And I think that might have a little bit to do with the FBI or maybe some other law enforcement agencies that the state has no control over, not turning certain things over. And the state is satisfied with what they have to prove their case, but the defense is like, well, wait, what about this, that, and the other that we think is important to our case or may hurt your case?
No, well, you're close. You're close, man, but not that many cigars. Okay, so yes, there is other entities that were involved in this investigation. Yes, FBI, Sheriff's Department, what do they call it? Washington University, including Spokane. Okay, Spokane, Washington. What the fuck is Spokane, Washington doing down here and getting involved with this? Okay, all right. Again, I'm going to say, Judge, what do you got to say to that, huh? Apparently, the prosecution has all they need, right? You don't say nothing. This poor woman is standing here clueless like a motherfucker, but you ain't explaining nothing. Help me understand what the hell's going on. And he said it was unusual. This is some unusual shit. I would hate to be in this man's position, sitting here, have gone through school, law school and everything, and to see this shit go down? Things that have never fucking happened? Are you joking me? Are you like, yeah, I deserve a like button. There's 18 of y'all. I know that you feel the same way. There's 19 of y'all. Come on. 9, add to 9. I know you feel the same way. This is bullshit. This is crazy. So the prosecution's ready to go. Boom. The jury already wants to convict, right? It's already, everything's set in motion. It's a done deal right there on their side. He is making sure that all their appeals are thrown away. Nope. No. Completely deny. That's him with this group. Okay? Nothing here. Just, it's a game. It's a fucking game. So I wonder what I gotta look into this attorney, find out like if there's any type of elections going on that adds him to it, due to his new notoriety, his new star status that's popping up now, because something's not right and it's political. I believe that they're using this case for some type of political situation here, and I'm gonna look into that. And I'm gonna if I find out anything, let me tell you, the world's gonna know. I'm gonna crack that case right open. Alright. I may not be able to do nothing for Mr. Bryan, but I got my eye on you, bro. Okay. I'm so sorry. I'm getting ready to choke him.
Oh my gosh!
That reminds me of me cooking. I like that fire.
One more question. So, I understand this. I mean, I'm aware of the amount of disclosures already. But do we need a whole another year after this summer? I mean, can I help everybody by
What?
having tighter deadlines to make things happen?
Wait, what? Do we need a whole nother year? What? Oh, okay. All right, Judge. You're making these decisions off of what you know so far, right? Off of everything you got from the prosecution, right? And any extra discovery you've received from Ann Taylor. Where does this sentence, all this verbiage come from? Like, help me understand. What? You understand what, Judge? And then, what, is it going to take a year? What, to you that it should take much less time? You are killing me here. Oh my God. Oh my Lord.
Faster so that we can get this trial sooner?
The judge is like, what can I do to move this so it doesn't take till summer of 2025? But the state has made all sorts of good arguments as to why the summer makes the most sense for this case in this trial, and I agree. The hotels, kids being gone, families not coming into town, the spectacle that it is. The defense is also going to try to change the venue. They said that, and we're going to hear a little bit from the state about why they don't think that would matter. But judge wants to move it faster. Maybe like a judge's compromise would be maybe over Christmas break or the winter time of 2024, early 2025, somewhere between summer of 24 and summer of 25, splitting the baby.
That's a tough question.
All right, wait. All right, so he wants to move it faster. The judge, right? Okay. All right, help me understand this. All right, the judge wants to move it faster. Okay, Judge. What do you know that Ann Taylor don't know? And that you feel that it can be moved faster? Okay. I would love to know. Okay, because like I'm not getting it. I'm lost. Now, hold on, I'm gonna rewind it a minute. I want to hear this one more time.
By having tighter deadlines to make things happen faster so that we can get this trial sooner?
The judge is like, what can I do to move this so it doesn't take till summer of 2025? But the state has made all sorts of good arguments as to why the summer makes the most sense for this case in this trial, and I agree. The hotels.
No, I agree too with the summertime. That's actually a good idea. But this now, all right, hear me out. He's denying all their appeals, all their motion, okay? but he wants this done faster. How contradicting is that? And when he's denying all this, he's not mentioning why. I didn't hear it. You know, like why he's denying it. Maybe I have to go back and listen again. I'm so sorry. Like I so wish I could communicate here. Sometimes I can. Sometimes I can't. If I do this, usually it activates, but it's not activating. Alright, no, I'm just not understanding this at all. So you're gonna deny, you want this case to be done, but you're gonna deny all these motions. So then basically what's telling me is you want somebody to go down for this crime. You don't care who, somebody has to go down for this crime. And that's all you care about. So rushing the prosecution, rushing the defense team ensures that somebody's going to definitely go down for it, and that would be Bryan Kohberger. Because that's not going to give them enough time to clear his name or find the real perpetrator. Because she's kind of stuck with now trying to find the real perpetrator, the real bad guy. Because the prosecution did not do their job correctly. They did throw away whatever it is that would have cleared Bryan Kohberger. And that's where she's gonna prove that. I don't know how good you're gonna look, Judge. Seriously, unless you come up with new perpetrators. Because this is what you got. You gotta hang this man. It's like hangman time, right? In order to make you look good. I'm sorry. My head's on. I'll probably get my head clear tomorrow. And then I can't even talk to you guys tomorrow. I have to wait all the way till Monday. Or Tuesday, I mean. Sorry. Between Tuesdays and Thursdays.
Kids being gone, families not coming into town, the spectacle that it is. The defense is also going to try to change the venue. They said that. And we're going to hear a little bit from the state about why they don't think that would matter. But judge wants to move it faster. Maybe like a judge's compromise would be maybe over Christmas break or the winter time of 2024, early 2025, somewhere between summer of 24 and summer of 25, splitting the baby.
That's a tough question. If the state says you have everything, and I believe they can say I have everything they have, but I know there's other things out there. I know it based on responses to discovery. If I had absolutely everything, all their experts' reports, I would still need a period of time to read and understand that. If there's not a shortcut for the amount of time that it takes to go through everything, there's just not a shortcut for that. Having a deadline for discovery helps me, but it just does. Having a deadline for expert disclosures, that absolutely helps me as well. I have the concerns of discovery that's not yet made available. I have the concerns of the time it takes to review all of the materials. And I have the concerns about the limitations we're finding with people being willing to talk to us, both for the innocence phase and the mitigation phase, should we ever get there. I have significant concerns. We're working on it. If you could say...
So people for the mitigation phase, or talk about Bryan Kohberger's life and stuff like that, may have nothing to do with this case, nothing to do with Idaho, but they're from back home, and they're like, we don't want people to know we were friends with him or are friends with him or support him or would say anything nice about him. We don't want to be connected to that. And that's tough, and that sucks for a guy that's presumed innocent at this point. Shy Gal said, so is she saying there's a specific protocol for at what point they get a DNA match that it wasn't followed? Could the DNA get thrown out? Is that possible? So we're going to wait until she files her motion to suppress to get the DNA thrown out. Is absolutely possible. Will it happen? I don't know. I want to wait until she's had an opportunity and her team.
I'm confused. I thought they said they weren't going to use the DNA. That they weren't going to use the genealogy either. That wasn't something that they needed. It's her that was pushing the DNA sequences and the DNA information. Because again, she doesn't see how they came up with Bryan Kohberger. She's still looking for how, other than the DNA or the genealogy, where I'm not going to say it right, speech impediment, how else did they pinpoint Bryan Kohberger? And besides the freaking car. So I don't want to hear nothing about the car either, because I mean, a lawyer has already mentioned that. So it's other than those particular items, how else? What else did they have that made them pinpoint him and nobody else? No one else. Out of all the DNA that was floating around in that house, outside of that house, including brand new DNA of people who never hung out at that friggin' house that had popped up apparently. What's going on here? Yeah, they think we all stupid, but here we go.
To review the DNA stuff that they're getting now, hire experts, put it together, because I would expect a motion to suppress that DNA evidence, and it can be suppressed or thrown out. Will it? I don't know. We've got to read those motions before we can really have a good opinion on that. Rebecca said, okay, what's the excuse then that they're not turning over the stuff, that there's going to be a reason here? There should be, and they're going to say either it's not relevant or the FBI won't give it to us or whatever it may be. But the state or the defense has filed a bunch of motions to compel, meaning we want this. State said no. Judge, you got to make a call. Judge says turn over at least part of what they're asking for. So again, it's frustrating. It happens in every case. But the delayed DNA and this much DNA, what did I say, 6.5 million documents worth, is wild. And that woman said, okay, Peter, you've been redeemed from doing your way too early members only by doing this Friday Night Live. Thank you for doing this, but enjoy.
Overwhelming. The pages for the DNA, huh? Something else I didn't know.
Friends would walk up to me and just be like, what the fuck is in your mouth?
What the hell's in my coffee? That's about right. What the fuck is in my coffee?
One time, so it doesn't come back. We can only predict the future so much. And I have so much power. So I'm relying on counsel. So let's go to Mr. Thompson. See what you have to say about all this. Just getting things ready for trial.
Ms. Taylor is not understating the amount of work that's involved in this case, Judge. I think that's fair to say, and there's more information that continues to be developed. You know, it's kind of like you ask one question, you get an answer, and that leads to another question. I know that Ms. Taylor and her co-counsel and investigators are encountering that. We're trying to provide things as quickly as we can, and she's right. There are delays in with the multiple agencies getting everything together. The tips, for example, were part of a nationwide tip line that needed to be completely shut down before we could get all the tips that were in it. And so that's why it took so long with these 9,000. I didn't count them, but there are thousands and thousands of tips, most of which are out there. But you're right, most of all of which need to be looked at to see if they have any potential relevance to the case.
It doesn't seem like they're disagreeing, right, with how much work and how hard this is going to be.
As I indicated to the court, if we cannot have a trial this summer, then I would say the earliest would be the summer of next year, for the reasons that I've described to the court about the practicalities of carrying on a trial of that duration with the high school, with the universities. We need to be realistic.
And again, sounds like an agreement. Summer of 25 seems like the best time. I'm very confident that's when the judge is going to make that determination.
Think about being sure that we can get our witnesses here. We'll have something to put them. And there won't be undue interruptions in the community that can cause issues with the community's perception of the trial proceedings. I'm not quite sure what else I can offer.
You're making some kind of argument that changing venue, but I know we're not arguing about that.
And, I don't think that's a changing thing, Judge. When this case has national...
What do you guys think? Because we've talked about this before, so you probably know what I think already. What do you think about changing venue? Do you think that would help at all? Do you think that would help at all?
I'm going to say no, that's not going to help at all. No. I mean, unless you're going to take them somewhere where it's a little harder for... I guess people to get to, or where there's not so many schools around, at one of those type of places. No.
Changing venue. Thank you so much, Roro, for gifting 5 members. Popping through here. Catherine asked if Kohberger waived speedy trial. Yes, but only because he was...
I'd really like to do this sooner than later. Maybe.
Sorry.
Towards a couple massages, except that this is not the standard to change venue. The reason they're talking about changing venues is because they say they cannot get a fair and unbiased jury who who hasn't already made up their mind about the case due to the media attention, basically. And the argument against it is, where are they going to go that people haven't heard about this? You can't like go to Alaska. He was talking about some small county maybe they could go to where there's no lodging, which makes the logistics of having a trial like this a nightmare. But it's not about it being a small town and people knowing each other and stuff like that. But a lot of people do think that, so it makes sense. Paula said, how is it the state's problem that people don't want to talk to defense? That's not the state's problem. That's not. The only thing that would be the state's problem is turning over discovery that they have and they're not going to turn over. But it is the judge's problem because he wants this to be a fair trial and the defense be able to do the discovery they need to do. So if they say we need more time to talk to these witnesses because it's difficult, then you give them more time. If they say it's impossible because the witnesses don't talk to them, you can't force them to really. And they're not going to be helpful if they don't want to talk to you, and they might just come in and say something bad for your client. John said, put this fee towards a couple massages for Whitney and yourself. We're going to some nice steakhouse tonight. It's called like Snatch or Scratch or something like that.
I pray one day I would have subscribers like this guy, John. Big hugs, right? Hey, come over to my channel here. Oh, that is a really good donation. All right, maybe one day I'll earn it.
Put it towards that. And I am very much looking forward to this. Apparently they have some nice wine and stuff Whitney's looking forward to too, but I'm going to get myself a nice steak tonight if I can stay awake. It's like 9.
I'm upset right now. I mean, I'd like to get
Catch. I was way off. That was like a Dumb and Dumber moment, like Samson, Swanson. Oh, Samsonite. It's right here on the back. And yes, I realize Snatch and Scratch. Like pause, Peter, pause. That's on me. That's on me. Hand up. That's on me. I'm the problem. It's me.
With discovery and see if we can have that more quickly. I'd like to speed it up if it's possible. I'd really like to do this sooner than later. I mean, maybe March 2025. With Hillary, that would be a reach. I just want to let it percolate a little bit. I know everybody probably here, including counsel, want to direct a certain date. But when you're talking about a date so long in the future, potentially, maybe we can get to a point where we can move it more quickly. I'm not going to just let it hang for too long, but it's really hard for me right now to set something in 2025, even though that might be just the reality. And I know that there's lots of other issues to be addressed. I know there are going to be a lot of motions. There's going to be a lot of motions about the death penalty as well. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we don't have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times.
So the judge is basically saying, I wish summer of 2025 was not what we were going to choose because that feels so far away. But that's what it seems like he's leaning towards. Bone Arrow said, but why was he forced? Wouldn't his lawyer have advised him on what to do? Like, not enough time to get ready for future trial. Yes, and that's the point. He's saying he wanted to go, he would have gone, but because the state wasn't giving him what they needed, and everybody was delaying this stuff, and the court wouldn't pause the case so that he could challenge the grand jury indictments more, he has no choice. If he goes to trial in the speedy trial time period, he's going to get screwed, and he's not going to have competent assistance of counsel, so he has to waive a speedy trial. Now, that's not usually good enough for an appellate issue, unless the state willfully committed prosecutorial misconduct basically by withholding things and didn't make legitimate objections and arguments. So we'll see. But that's what he meant when he said he was forced to do it. Jazzy's mom said no notification.
Yeah, that's kind of what I was trying to get back to. So him, Bryan Kohberger, waiving his speedy trial was because he felt forced to do so. And I felt that a long time ago, so I understood that. So it's not new news to me. I understood as soon as he did it, because if he would have went for the speedy trial, his defense team would not have what they need in order to actually defend him for that speedy trial, because of how much information that was being held tightly by the prosecution and still is. So
Probably my fault. I'm on vacation. I didn't set it ahead of time. John's not here. I just decided to go live instead of record something to play later. So I apologize, but I'm glad you're here now. Catch up, 2 times speed.
Because no matter what happens, okay, if he's convicted, it's going to be appeal. And
Everybody agrees with that, but who cares? Appeal. If he's not convicted, or if he's convicted, should not affect our decision making now. What we need to worry about now is getting a fair trial, due process, all the evidence turned over that needs to be, so both sides can make the best argument they can, so this trial is preserved. It's going to get appealed. It's going to get appealed no matter what. We can't control that. If he's convicted, it's going to get appealed. Thank you, Netwoman, for
see, that's exactly. I 100% agree with those words. That's why I couldn't understand why he was so diddle-dallying. Well, if I do this, and it wouldn't matter anyway, because it's going to get appealed. What is it? You're not going to be a part of those appeals? There's going to be a different judge or something? Like, you're afraid somebody else is going to get your stardom that you're having right now? Oh, like, I know that, lawyer, did not say what I said, but I said what he said on my last live. So I'm just watching him, and I did not watch him when I did my live on this trial, because that was live. It was live and ready to go. Okay, so I didn't have any time for major commentary. However, I did talk a little bit through it. I did pause and say, hey, this is what's going on, as we kind of went through it. And he basically said what I said. Not in so many words, obviously.
gifting 10 more memberships. Great membership or a great live to show up.
It's going to be. So it's realizing to think that we have to have a case so far in the future. But if that's what is the right thing for everything to do it correctly, maybe we only have to do it one time. Because we don't want to do this twice. We don't want to do this 3 times.
So the judge is basically saying, I wish summer of 2025 record something to play later. So I apologize.
If your life is hanging over your head. So, sorry.
The Samsung S24 is here, and this is a mouse case.
I have a Samsung. You know what happens? Every time I text somebody, oh my god, it's playing again. It changes my words to words that I've never said. And it's really bad, some of the words that come out when I text. Oh, sorry about this. Here we go.
We'll see. All right, so I'm going to contemplate a little bit. It's not like I have to set this within 2 or 3 months, apparently.
So he's going to pause. He's going to contemplate, which means he might not just jump into this summer of 2025. Maybe he'll set it for March of 2025. That's if I was the judge and I was trying to push this case. I might set it for March of 2025. Hope everything is perfect. Try to push everybody to fix everything or to finish everything. Set all the deadlines for March 2025 with in mind that I would allow a continuance to the summer of 2025, which is just a couple months after March. So build that in. That's probably what I would do. But I think in actuality, the soonest this case goes to trial is summer of 2025.
Well, yep, that's basically what I said in my last live. Hell yeah. I knew that even though he wants to sit there and say March, they still can move it to the summer. And that's exactly what I said. I don't even have a law degree. And so far, almost every word that came out of his mouth was almost just like mine. Just very close. Of course, I did put, my own 2 cents in there that's not as professional. Like, bullshit, fucking liar, son of a bitch. Alright, you know what I'm saying. Okay? Hit that like button. Sometimes I'm raised by wolves. I was raised by wolves. Here we go.
Thank you, Catacomb Man, sending love, Pete. May the truth prevail. Yeah, whichever way that is. That's what we always want. And Carolyn, thank you for gifting a membership. Mandy said, if the defense...
Oh, I'm so jealous.
LawyerYouKnow.com is where all the merch is. LawyerYouKnow.com, check it out. Are you looking for something?
Oh, he's got merch too. I gotta start doing that. I'm an artist. What the heck's wrong with me? All right. So let me see if we can get this thing going here. I can't get it working. I have it set so it works, so you guys can talk to me. The hell. Ugh. And usually when I do this, it gets going. And sorry, I'm just trying to get the text thing going here. Now all of a sudden, don't want to work. All right. Well, you guys can comment. Don't forget to hit the like button. You know I deserve more than 15. So if you watch my last live event, let's find me. Where did I go? Oh, where am I? Oh, there I am. Oh, look at my cute little face. Okay, there we go. Now, the reason why I put 100% there is because I agree with him 100%. So if you go to my last live, this is part 1. And you'll hear my commentary. And yeah, I was more mature when I did my commentary here. I didn't go crazy. I only go crazy at night. Alright, so yeah, sometimes I turn into a wolf. That's just what happens. Alright, and in here, I was a normal human being. Okay, so yeah, don't forget to watch part 1. This is part 2, and then I'm going to have a part 3. You're probably like, oh, what else can you talk about? No, you'll see what I'm going to talk about, what I'm going to add to all this commentary. Yeah, because, I got to start becoming a creator, right? So, why not? Okay, so part 3 will come out, and it will be different. It won't be what you expect. Okay, it will be different. Alright, thank you guys again for being here. Hit that like button. I truly can't wait for part 3, but it won't be till next week. I think I may do it on Tuesday. I may not be ready. Might have to do it on Wednesday. But my part 3 is, it's going to be way different than this. I'm not doing a commentary. Okay, but I'm going to add certain commentaries, to where I would have commented or where he has commented. So you can get other point of views at the same time. Oh, I'm so excited. I don't want to totally tell you how I'm going to do this because somebody's going to beat me to the punch. So I think the more I say anything, somebody's going to beat there. Somebody's going to be able to do this faster than me and put it out. So again, don't forget to join the Patreon or Buy Me My Coffee app. Patreon, I guess people usually go to. That is where you'll get the link when I start the chapters, which is a 3D investigative chapters. So once I get a little bit more info, I'm going to be starting that and including, once I'm done with my characters, rigging them the way I want it, we're gonna do a little movie. It's gonna be interesting. But again, I don't want to totally put out what I'm going to do because I'm being copied by someone else who likes to do animations. So I don't want them to beat me again. Okay. Like they continue trying. Alright, I love you all. Don't forget to hit the like. Don't forget to comment. Hopefully I made you laugh. And love you guys. Good night.